I'm Muriel Bowser. I'm the mayor of Washington, D.C., the best city in the world, soon to be the 51st state. And I am calling to order this scheduled meeting of the New Columbia Statehood Commission. I would like to recognize the co-chairman, Phil Mendelson, and members, Senator Paul Strauss, Senator Michael Brown, and Representative Franklin Garcia. So all of the members of the commission are present. We have circulated a draft of the agenda, which is before the members. And I would like to suggest one amendment to the agenda. Following Roman numeral 2, I would like to include a discussion by section of the draft Constitution and by section of the public comments. Is there any objection to that addition? Okay, hearing none, the agenda is so changed. Let me thank everybody for their participation in drafting the Constitution for our new state and preparing to take that message all over the District of Columbia and indeed the entire nation. I want to thank all the members of the working group and the Legal Advisory Committee and all of the hundreds of people who took time out on Friday night, on Saturdays, to make comments on the draft. And I think that we have, out of all of those comments and out of all of that discussion, we have found that there are, several buckets that we really want to drill down on and continue to ask questions about, and I look forward to doing that with my fellow commissioners tonight. So with that, let me turn to the first item on the agenda, and that's to hear from all of the commissioners. Chairman Mendelson.
I don't have any opening remarks to make. I will say something about the council process at the end of the meeting, and I look forward to the discussion this evening. Thank you.
Thank you. Senator Strauss.
Thank you, Madam Mayor. It's a privilege to be here tonight, and one of the things that has struck me throughout this process is the enthusiasm that district residents, both in and out of political life, have had for this process and the enthusiasm that this has generated. We have received a lot of comments. It is exciting to see the public engaged, and as I was rereading some of the earlier drafts of the Constitution, I came across, I refamiliarized myself with the amendment process that the delegates to the first Constitution put into the 1982 version. And under that original Constitution, those delegates gave to the Council of the District of Columbia the express authority to make amendments to the 82 Constitution prior to any time that it was enacted.
To the microphone.
And so the Council enacted that in 1987, and a lot has changed since then. One thing sadly hasn't. We still don't have the full democratic rights that 1982 Constitution envisioned for the citizens of the District of Columbia. And so as our community has grown and our institutions have developed, we need a new Constitution that will reflect the changes that we have. And many of the concerns I've had about the accelerated nature of this process, whether or not people would engage and participate, have been abated as I've sat there and seen comments come in from all over the community. And even as I was coming here today, the level of input and calls that I got from citizens wanting to make sure that we had read their comments, heard it. This has been a process where the citizen engagement has exceeded even the ambitious hopes that I think we had when we began it. And I look forward to moving forward a document tonight, having the council pass it, most importantly, having the Congress of the United States quickly adopt it so that we can take our rightful place in the American Republic as full and equal citizens. So thank you, Madam Mayor, for kicking this process off. Thank you, Chairman Mendelson, for your leadership and vision in creating the new Columbia Statehood Commission. And I want to thank all of my colleagues and our staff and volunteers who have put in more hours than we thought we would have over the summer to make this process the success I think it has been. Thank you.
Thank you, Senator. And Senator Brown.
Thank you, Madam Mayor. I agree with my colleague, Senator Strauss. This has been an amazing process. So many people have been involved. I want you to know that I've heard from many of the activists. I've done everything I can, even though I'm a volunteer at this process. I've read all 4 constitutions. I've read every comment that's been submitted. I've tried to faithfully fulfill the obligation that's been put upon me. I know so much about constitutions, I'm thinking about starting my own country. The first official act, of course, will be to build a wall specifically to keep Donald Trump out. But seriously, I know that there have been a lot of complaints about the process. And, you know, has it gone quickly? Yes. Has it been absolutely as inclusive and collaborative as it could have been? No. But we need a constitution to become a state. And this Constitution, I can tell you, is a better Constitution than the Constitution we have, and it's more democratic because we've listened to every comment, and there's been more than, well, Karen Zolgin on our staff tells us 90 changes made in response to the comments we've received. So is it perfect? No, but it's better than the document we have, and I hope that we can move it forward and keep this on track. Thank you.
Thank you. Representative Garcia.
Thank you, Madam Chair. I, too, want to thank the other members of the Commission for getting us where we are today. On April 21st, under the vision and leadership of our mayor, we laid out a very aggressive and ambitious timeline to revive the Tennessee plan. And if everything goes as planned, this will go to the City Council and then subsequently to the Board of Elections, and the voters will have the opportunity to say whether the District of Columbia should be a state. We have a great opportunity with a new president coming up and the 115th Congress inaugurated, hopefully a Democratic Congress, to become the 51st state. And I hope that we are ready and we can take advantage of that opportunity. Thank you, Madam Chair.
Thank you, Mr. Representative. And so, with that, all of the members, and I apologize for this not sounding too well. Maybe that's a little bit better. To all the members have before them a report about the analysis and recommendations that are now before the Statehood Commission. It is entitled Constitution Commission Report. You also have the updated draft of the Constitution, and you received to review both a final copy and a redlined copy. And you also have the public comment log, which has been posted on the Commission's website. It's been updated after every public meeting, and the final comment log is before you as well. And I would entertain a motion to accept these documents for the Commission's consideration.
So moved.
So it's a motion?
So moved.
And? Second.
All those in favor say, any discussion on that? Discussion. All those in favor say aye. Aye. Any nays? The ayes have it, and the documents are accepted by a unanimous vote. So let me now turn to the sections where new item number 3 to discuss the comments. So part of we received a lot of comments on whether, well, before I'll go through the sections, and then we will go to general comments at the end. So we received a lot of comments around the Bill of Rights, what should be included in the Bill of Rights, if we need a Bill of Rights, should the Bill of Rights repeat as is what is in the first draft and the second draft, the federal Bill of Rights. Should we remove some things? Should we, add other things? And so what is before the members is to include a Bill of Rights and to mirror the federal Bill of Rights. And I wanted to acknowledge first to see if the members had any comments that they want to put on the record, but also acknowledge that Alan Morrison, who is a professor at GW and has participated in our legal committee, would be happy to offer some comments. Commissioners?
Well, Madam Mayor, I think we need a Bill of Rights. I think that this is our opportunity when setting forth our priorities as a new state to speak to the state that we want to be. So I think we do need a Bill of Rights, and I think it needs to be expanded.
Okay, any further? Professor Morrison, did you want to add anything? If so, there's a microphone here.
Thank you, members of the Commission. As far as the question about expansion is concerned, we have laid out some considerations, and it's a judgment for the Commission as to whether expanding the Bill of Rights is sensible. Of course, we realize that nothing prevents the House of Delegates from creating new rights, expanding additional rights. And the question before the Commission is, should we put them in the Constitution? And if so, do we know enough now to be able to carefully define them in a way that will be protecting everyone forever? And that's the question for the Commission. So the question is not whether we should have expanded rights, but whether it should be part of the Constitution.
Thank you. Any further questions? There were a lot of comments made about goals that we have in the district, some of which are, codified in our law and protected in our law. Others are aspirations of our city. And what we were careful to do is to make sure that the Bill of Rights, like the federal Bill of Rights does, limits the power of the state and doesn't encroach on our individual rights. And so I felt strongly, even though there were a lot of things that were mentioned that I firmly believe that we should protect in our new state, they're probably better handled by statute. And so that is why I will vote to maintain what was in the first draft with the 10 Bill of Rights, the 10 protections. Any further comments? Okay.
Are we voting on the language now, or we're just presenting and accepting comments from the legal committee on that section?
We're taking any comments, and we will take a vote on the Constitution. What I've heard so far represents no change in what is in the draft.
In the draft, actually, we had circulated a proposed amendment that had been discussed. So just in terms of, specifically in terms of Section 4, there was a version of the draft, not the circulated, but it looked like there were some comments that had suggested on the right to a jury trial what would look like constitutionalizing a statute called the Misdemeanor Streamlining Act, which denies the right to a jury trial to those who are facing less than 180 days in prison. And I had some concerns about putting that in our Constitution, and I thought we should stick with the 1987 version or the original draft language, so that the right to a trial by jury, if you're looking at even 5.5 months, which I think some would find a substantial deprivation of liberty, would be protected. And then I was also committed to keeping on the access to civil justice the original jurisdictional amount and not doing anything to restrict that. I think that while jury trials are rare and issues of small claims court and things like that, they have become important in some of the other branches such as landlord-tenant court, where the dollar amount in controversy might not be large, but those issues are often important to the litigants who are there. So, again, I saw some drafts in which access to juries would have been restricted under our Bill of Rights, and would have, I think we should go back to the original language that would not have restricted juries, but in fact protected those rights. So.
Would you like me to respond?
Please.
Yes. Under no version of the amendments that have been proposed would the jury trial be restricted, so that if the House of Delegates wanted to have jury trials in small claims court, landlord-tenant court, or they could, or in misdemeanors or traffic offenses for that matter, they could. The question is, as written and as adopted from the federal Constitution, in a civil case over $20, right, which of course was written in 1787, not 2016, and in all federal criminal cases, no misdemeanor accepted, there's a constitutional right to a jury trial. And the proponents of that change believe that we shouldn't tie the hands of the House of Delegates and require it to have a jury trial in all these cases. But there would be nothing that would prevent a jury trial in any case, even cases that would have been heard at equity, and that's been the practice in the federal system for years. So it's not that they're being denied, it's just that not they're going to be forced, and so they would have to amend the Constitution down the road if you, for example, decided no more jury trials in landlord-tenant or small claims court. But that's a decision down the road, and we felt it was better not to lock in the House of Delegates.
So, under the current language, I guess the red line draft that I got, it looked like there was language that would only guarantee jury trials in criminal cases where the deprivation of liberty exceeded 180 days.
That's correct.
So.
And that's the federal constitutional standard as well. And nothing prevents the House from having a jury trial in any case that they want to order it. But, of course, that costs money, and it takes time, and it takes jurors away from other people. So we thought that was a matter best left for the House of Delegates, rather than constitutionalizing it for every one of these cases.
So is your question, Paul, does it change a right that is in current law or in the current charter?
Well, I think in current law, by statute, the right was curtailed. And I don't know that we wanted to constitutionalize, memorialize that statute. And I don't know that there are, I think it's inaccurate to say that that there aren't jury trials in equity as when in small claims court or landlord-tenant court. I think they exist.
I don't think in any event, the original Constitution, the federal, and our current draft says that common law, so equity wouldn't be included in that, but that's a matter of interpretation. And the question is not whether there are jury trials now, but whether we should lock in the new state to have jury trials forever without having to amend the Constitution. And I think that's the question. It's the lock-in effect that concerned those of us on the legal team.
And this was something the legal committee debated substantially?
Absolutely.
Okay.
Thank you.
All right. Is there an amendment, Paul?
I do think I think with all due respect to the committee, I would like to strike the language that says 180 days. I think if you are facing a deprivation of liberty of 5.5 months, that is a significant deprivation, and I think that in an abundance of optimism that we're voting on a document that will soon be carrying legal effect. I would move that we strike the 6-month language and just leave that the right to a jury trial in criminal cases where you're facing jail time be preserved.
Okay, there's a motion. Any comments? Any discussion? Yes.
Well, I'm completely sympathetic to the intent behind what Senator Strauss is moving, I will not support this, and I will be voting against this amendment to strike it. I chaired the committee, council's committee on judiciary for 8 years and dealt with this issue firsthand and up front. And I can tell you that there was a day, in fact, it was a weekend, in which between the committee markup and the council vote, there was we struck the language about 180 days so that a jury trial would be required just in misdemeanor assault cases. Now, the issue for those who are here watching, under case law, if the maximum sentence is 180 days, one does not have a right to a trial by jury. And if it exceeds 180 days, that's 6 months or longer, then one does have a right to a trial by jury. And what we did in a committee markup was to say that for assault cases, misdemeanor assault, there would be a right to trial by jury regardless of the fact that the sentence was no more than 180 days. And it became apparent in the space of one weekend between Friday and Monday, communications from the court and from a lot of attorneys that the judicial system in the District of Columbia would grind to a halt because of that. We would see far fewer prosecutions of misdemeanor assaults because it would be very time-consuming, and we would see the need for significantly expanding the Superior Court, which right now I believe has 60 judges, enlarging it to be able to handle the caseload of the jury trials that would be required just for misdemeanor assault. So I think that there's flexibility here for the legislature to act by statute, and I think that's exactly where this should be left, because there are other considerations, which are namely that we want efficiency in the ability of the government to prosecute where there are allegations of misdemeanor crime. And the effect of putting this in the Constitution would work against that. So the intent is good, but the effect would be very regrettable.
Can I ask Mr. Morrison a follow-up question?
Sure.
If the federal provisions are restricted to 6 months, why was the original 1987 Constitution, as I read it, didn't have didn't get that specific when it came to trial by jury? So why would we need to codify 180 days in the language of the Bill of Rights here if we're really just mirroring what the federal law or what current law says?
I'm not sure I understand the question.
You probably need to use the microphone.
Yeah.
The federal Constitution is a guarantee in federal criminal cases in the federal courts, so it doesn't apply to the District of Columbia. I'm not quite sure I understand the question. I think the concern is, and Chairman Mendelson has expressed it, is that we're forcing the hand of the legislature to provide for jury trials in all criminal cases. And since the federal Constitution has been interpreted to require a jury trial in states only where there's over 180 days in prison, many states have decided not to have jury trials, and the Supreme Court has upheld it. And we thought we'd bring this in line since we're trying to be like other states.
Okay, thank you.
Okay. So there's a motion, and I will say that I'm persuaded by the comments I heard from Chairman Mendelson and Professor Morrison about having more flexibility to deal with this by statute. And so I wouldn't be supportive of it. And I'm wondering, Senator, if this is a matter that we can pull back presently and move on to another article? Would you be willing to withdraw it?
Absolutely,
okay.
Madam Mayor. I'll withdraw it at this time.
All right.
Madam Chairman?
Yes.
I'd like to propose a motion as well.
Okay.
I think that we should include in our Bill of Rights a right to education, which many states have, a right to vote. If there's any state constitution in America that should have a right to vote, I think it's the Constitution of New Columbia, which especially since we've seen attacks on the 64 Civil Rights Act and the 65 Voter Rights Act. And I also think as a leader in America on LGBTQ rights that we should also make that part of our Bill of Rights, because I think our community firmly stands on the principle of equality. So I would make a motion that those three issues, those three things be included in the Bill of Rights.
Thank you. There's a motion. Discussion. I'll speak to that, and I agree with all of the things you just said, except for expanding the Bill of Rights at this time, because I'm sure if I scanned the room that there would be other things, and even other things that came up from our commenters about what to add, and as I said at the start of my comments, that's why I am going to stick with the protections that are listed in these drafts. Any other comments? Mr. Chairman?
Yes. Let's just start with the first point, which is a right to education. I view the Bill of Rights as being a limitation on the powers of government. And I think that your proposal, Senator, goes in the opposite direction. That is, it's aspirational for what the government should do. And I don't think that's appropriate in a Bill of Rights. I look at language. Now, you didn't propose specific language, but we received some, not talking points, but I guess discussion briefs. And what it says with regard to right to education is, for instance, the state of New Columbia shall provide for a system of high-quality public educational institutions. Well, what exactly does that mean? And so if my daughter goes to a public school where the PARCC scores are not rich, does that mean then that I get to sue the government because it's not providing a, quote, high-quality public educational institution? And I'm not sure that's what the Bill of Rights should be about. That should be what is left to the legislature and the executive to put into law. That's where policy should be. Again, it's aspirational. It's not a limitation on the government. That's what the Bill of Rights in the federal Constitution is limitations on the power of the government. So I think that I think that while what you're suggesting is laudatory, I think it asks for trouble.
Well, I would only argue with that, Chairman Mendelson, that I think the Bill of Rights was put in to guarantee, according to the Federalists, to guarantee the rights of people. I think the First Amendment doesn't limit the government in interfering with your right to speak. I think it guarantees you the right to speak and the right to associate with who you want and the freedom of religion. I don't think it limits the government. I think it empowers the individual. And that's all I would say there. I mean, I think we have a basic disagreement on that.
Okay. Further comments?
I worry that we would be making the mistakes that our original crafters of our Constitution made in 1982 when we deviated from what was necessary and yielded too greatly to our aspirational hopes for what we hope our new state would be. My goal here tonight is to come up with a structure of a government that will, in the end, in a new free and sovereign state, provide for a quality education for all of its citizens and provide all of the aspirational goals that you spoke about. But I think the best way to do that is by restricting the Bill of Rights to those topics that were traditionally covered under federal law and by other state constitutions. So I regret to not be able to support my colleague on his amendment.
Okay. Further comments? Would you like to proceed with a vote, Senator?
Yes, please.
Okay. So there's a motion on the table to add 3 additional rights to the Bill of Rights. All those in favor say aye.
Aye.
Those opposed say nay. Nay. The nays have it, and the amendment fails. Anything further on the Bill of Rights? Okay, we'll move on to Article 1 of the draft Constitution, which focuses on the legislative branch. The draft was presented on May 6. And the legislative branch closely mirrors the current structure of the Council of the District of Columbia. The new House of Delegates would be a unicameral legislature consisting of 13 members, including a Speaker of the House, 4 at-large members, and 8 members elected from individual legislative districts. The term of office for delegates would be 4 years. The legislative power of the new state would be vested in the House of Delegates and would extend to all rightful subjects of legislation within the state. In addition, Article 1 would maintain the current Advisory Neighborhood Commission structure, including the powers of the ANCs included in current law. I'm pleased that John Bowker here, who's a partner at Arent Fox, would be happy to answer any questions related to Article 1. But let me now open up for any discussion.
Well, again, Madam Chairman, I think the one comment that we've heard most during this comment period and during the Constitutional Convention, and with those comments that have been submitted to the Commission, is that the size of the legislature is too small. I think that when we look at legislatures around the country, we see that the smallest is a unicameral legislature in Nebraska, and it has 40 members. 2 states that, 49. I stand corrected. I think that the 2 states that are smaller in population than the District of Columbia, Wyoming and Vermont, have 90 and 45 delegates. So I think that 13 delegates is woefully inadequate, and I propose that we go with the 1987 Constitution and have a House of Delegates that's 25 members.
Okay, thank you. Any further comments?
One of the things we've heard when we've talked about the size of the legislature is, and one of the things that's always bothered me when critics of statehood for the District of Columbia have argued the case, is that we are too small geographically to be a state, and that our state just doesn't look like other states. Because we are small geographically, and we all know that if you don't know, you should, that our population exceeds that of 2 states, is roughly comparable to 2 others, and that we meet all the requirements for statehood. Presumably that's why we're all in this room. But I think there are differences between us and the state of Nebraska, and that, one, any citizen can get from the farthest corner of our new state to the Capitol building of our new state, even with the worst traffic, even with a metro system in need of vast repair, probably within an hour or so, and can avail themselves and make themselves present at the legislature. And I think that when we look at and compare ourselves to other states with small populations, we have to recognize that there are some fundamental structural differences that mean that maybe Nebraska or even Vermont or Wyoming aren't exactly the best models despite our comparability in population size. So I don't know that we need to be guided by a large legislature. I have concerns that our critics, if we expand too much, will attack us for using statehood as a way of raising people's taxes, creating a lot of jobs for politicians. That being said, at the risk of sounding superstitious, I don't know that 13 has been the luckiest number all the time. So I don't know that I am necessarily committed to maintaining that number, but I do have concerns about wholesale saying Nebraska does this, New Hampshire does that. I think that we need to be free to have a state government that reflects the uniqueness of us as a character, as an urban jurisdiction, and recognizes the reality that the close geographical proximity that we have to one another gives us the advantage of being able to gather in a way that citizens of larger geographic states, even those with smaller populations, can't. So I am not unmindful that it has probably been the most discussed item, and I look forward to hearing more discussion.
Thank you. So I wanted to jump in, and I appreciate all of the comments, and certainly I do agree that it is, there were probably two top comments that we got, and this is, I think, the biggest. As a state, won't we need more people to help us govern the state, and don't the people of the District of Columbia want more democracy? And is 13 people enough to be responsible for the budget and all the laws of the new state? So I approach this with a lot of concern, because I know that the recommendation that I'm about to put to the members, their views on all sides, and so I approach this knowing that people want more democracy, and knowing also that we need more opportunities for political talent to grow in our new state, and having a larger legislature would be one such way that we could do that. I am also, like the senator said, mindful of making sure that we aren't ballooning our government. That is not the point of statehood. The point of statehood is for us to get our 2 senators and to get our fair share in the House of Representatives as well. So what I suggest is somewhat of a compromise from what the people wanted in 82, what the council decided in 87, and even what we have considered among the commissioners. And having had conversations with everybody here, I know that there may not be a unanimity of opinion, but that is what we will strive for. That is what we will strive for today. So what I would move, an adjustment to what the senator has already spoken about, and an adjustment to what was approved by the council back in 87, which was 25 members. I want to move that we amend the draft to say that the House of Delegates would be a 21-member body, having 2 members from each legislative district, 4 at-large members, and an at-large chairman. Or not chairman, speaker.
Madam Mayor, I would second your motion.
Discussion.
At some point, I have to speak up on this. I'm in a bit of an awkward spot on this. The Constitution is going to be approved, we assume and hope, tonight by the Commission and then submitted to the Council. The Council has not weighed in on this at all. And here we are discussing a matter that's fundamental to the Council, even though the Council would become the House of Delegates. In as much as I am the representative of the Council here on the Commission, I can't advocate a change that I have no sense of where council members are, other than a comment that was made this morning that if we are to have a state legislature, then we have to remember that there are city functions, and city functions require a smaller legislature. Now, I sat through the 3 days of the convention, and I recall that there were folks who argued to increase the size of the legislature, with the exception of one witness, and argued for a larger legislature for reasons such as it would be more democratic. And I would argue that size is not more or less democratic. What is fundamental to whether we are democratic or representational is that we are elected, not the number of us. There were some who argued we need a larger legislature because then it will be less corrupt. That doesn't follow at all. were folks who were sort of in the same vein saying, well, you know, if we have a if we have a larger legislature, then we have a more representational legislature, a more democratic legislature, and therefore a better legislature in terms of reflecting the will of the people. Of course, that's kind of subjective, but I would note that the legislature that we have, many argue, and in fact I heard many argue today when they didn't like legislation pending before the council, that we have perhaps the most progressive public policies in the country. And I don't know that that's so as certain if we have a larger legislature. The role of a legislature is, I think, critical in the function of checks and balances in a government, that you have a check on the executive. A larger legislature, at some point in terms of size, becomes a check on itself. And the most obvious example there would be the Congress and the House of Representatives, actually both branches of the Congress. Obviously, nobody's proposing anything of that size, but it makes the point that larger becomes more difficult to manage and therefore becomes more difficult in terms of performing the role of checks and balances that I think is most critical in a well-functioning government. When we look at other states and we look at the size of their legislatures, we're talking about very different legislatures, and we're also talking about something jurisdictionally that's very different in terms of geography. And does geography really matter? Well, if you think of almost any state, in fact every state, which has a rural area and an urban area and probably has multiple urban areas, you wouldn't want a member who's representing a large city as well as all of the farms in the west part of the state. It makes sense that you would have more legislators just by, not because of the number of people, but the amount of territory that they have to cover. My point being that becomes very difficult quickly to make that comparison. But to me, what's fundamental is that we don't become more efficient and we don't become any more representational if we become larger. And in any event, this is a matter that I cannot tell you where the council is. And so other than what has been pending since this draft was first put out, I can't support.
Senator?
I would only say when it comes to size, I think size is important. And this is why I don't want to go with the 82 suggestion that we have 40 members. But size is a limiting factor. In Alaska, for example, you have a larger state than every state on the East Coast combined. Yet you have a single member of Congress. It's based on population. It's not based on the size of the territory. And we have a population that would support, I think, a 25-person legislature. And when it comes, the one place I disagree with Chairman Mendelson is I've worked in local politics and I've worked in national politics. National politics is less corrupt. It's harder to corrupt the federal government because there's more people in it and it's harder to reach out. It's a lot easier when everybody knows each other to have corruption. So I think it is a foil against corruption.
If I may,
Representative Garcia?
Yeah, Madam Chair, I too concur with Senator Brown and will support the 25 number. And I think the logic behind that was that it would be 2 members per ward and then 8 at large and a chair. And I hope that as we move forward, that every member of the City Council had an opportunity to come before the committee various times and provide input. And so I'm hoping that we're not in the process of deciding tonight that we're not giving preference to any particular group over the what most people want, which I think over and over we've seen that the size of the legislature is one of the main things that everybody has commented, and I think 25 or even 21, but I think the 25 is a better number. For example, we've never had a member of the Latino community be on the council, and I think that increasing the number would actually increase the odds of eventually having a member of the Latino community be a member of the council.
All right, very good.
Let me, to those who've, this is a process where I'm advocating for what I hope will be a united community solving its problems against the real legislature that's been a problem. And it's not the Council of the District of Columbia, it's the Congress of the United States. And so our goal here is to find a strategy that will get rid of the 535 superfluous members of our legislature that have no business interfering in our policy, have no business interfering with our laws, and come up with a structure that will work for us. I don't think that the attacks on the council for integrity or functionality based on its composition are in any way appropriate. I don't think that this is the proper forum for folks who have any grievances on particular legislation or things that are moving there to address them. This is our chance to come up with a structure that will help us function as a state. I think the Bowser Compromise, for lack of a better word, has some merit in that it gives each electoral district 2 members, just as each state gets 2 senators, but does not essentially create what I fear would be a de facto upper house of 9 additional elected citywide members. It remains an odd number, and I think it's consistent with the goal of a limiting the transition to what may absolutely be necessary. And while I certainly heard many people speak to the size of the legislature, I think it's a little bit inaccurate to say that everybody who came before us made that their number one concern. It was a loud concern, but I don't necessarily think that it was the overwhelming one per se.
All right, so the last thing I'll say about this is that I hope that everybody is viewing this from a lens of a future council and a future governor and a future that we're not deciding on our own positions, that we are deciding what's going to happen in our new state, whoever the officials are. And so I just think that that point is important to remember. I think that we will all be judged by that, by our willingness to figure out how our new state will best function. Likewise, I think people will judge us if it looks like we're only trying to protect our own power. And so I just ask that everybody think about that both now and in future deliberations. And I want to put the fine point on it that we were all pretty mindful of having a streamlined document and advancing a very prudent plan. And I think the motion that's on the table is for 21 members. So I'm going to ask myself the question I asked all of the other movers of the amendment: do I want to withdraw it so that we can get to unanimity? But I do think it's important because to be responsive to the request for more democracy, and also my firm belief that we could actually do the work of a $13 billion currently entity with more people, and we could better develop talent in our city with more positions. So with that, I'm going to call for a vote on the motion. All those in favor say aye. Aye.
Aye.
Any opposed? No? Brown?
No, I'm aye.
Aye.
I'm not gonna
Okay,
tell
so
them.
the motion, the amendment passes, and Article 1 it will be changed. I do have to ask for order. Article 1 will be amended to reflect the size of the House of Delegates being 21 members, 2 from each legislative district, and 4 at-large members, including the at-large elected president, Speaker of the House of Delegates. Moving on to Article 2, the executive. Article 2 sets out the powers and duties of the executive branch, including those of the governor, the attorney general, the chief financial officer, and the Board of Education. The draft constitution released by the commission in May was designed to reflect the current makeup of the district government, in keeping with the first guiding principle adopted by the commission. And so with that, I would like to recognize that Shelley Broderick would be happy to, oh, you're number 3. We're on number 2. Who's number 2? Walter Smith. You're number 2. Walter, do you have any comments on the executive branch changes? Okay. Commissioners?
Again, Madam Chair, I'm for an elected school board. I don't think it should be an advisory board. I think it should be elected by the people. It is singly the oldest elected office in the District of Columbia. Before we had any rights, we had rights to elect school board members. I think to have an independent school board is important to the quality of education in the District of Columbia. So I would move that we amend Article 2, Section 7 to say that our school board is elected and not advisory.
I think as I read the document, I think it provides currently for an elected school board. And in fact, if anything, it constitutionalizes an elected school board where one is now primarily a creature of statute. So I agree with you, Senator, but I think that as I read it, the State Board of Education shall consist of one member elected from each legislative district and one member elected at large. I think the only change was that we changed the number 9 to one legislative district, which makes sense in case we ever change the number of legislative districts. So it allows flexibility, but I think that however many number of legislative districts we have, the language that's currently before us says that there will be an elected school board, and that each legislative district will have one member as well as an at-large member. So I support your sentiment, but I don't think we need an amendment. I think the language provides for an elected school board, and I think that elevating that elected State Board of Education, which is currently a statutory office, to a constitutional one, demonstrates our commitment not just to quality education, but to democracy as a way of guiding our educational system.
Well, I stand corrected, Senator, but I will say that the point that I was trying to make is that under the powers of the elected school board, it says the State Board of Education shall be responsible for advising the governor on educational matters. I don't think it should be an advisory board. I think they should have the power to make decisions on their own. And that was the point I was trying to make. I'm not a lawyer, so I'm sorry I misspoke.
And I think, if I might add, I think that the Constitution reflects what's in the current law. So we're not changing the powers of the state board, but as the senator said, they are being they're being memorialized in the Constitution, whereas now it only resides in the statute. Is that a motion, or is that a comment?
That was a comment.
Okay. All right. Any other comments on the executive? We received a lot of comments about the powers of the Attorney General, and your red line version reflects additions to the Constitution outlining those powers. We received a lot of suggestions not a lot. We received suggestions related to the addition of a new position in the state government of lieutenant governor. I think the commissioners elected not to advance those recommendations in trying to maintain a streamlined government. And that is likewise the case for the Secretary of State and Treasurer. Any further comments on the executive? So I have recorded no changes to that article. All right. The next article is the judicial branch. And Shelley Broderick is available to make any comments or ask questions about the judicial branch. Questions, comments? Dean Broderick, why don't you just say a couple of things about what's reflected in our draft?
And actually, I'm assuming that there has been some consultation with members of our judiciary as well.
I don't know. I didn't personally, but basically what we did is put forward what we now have in place with a couple of changes. One is that, of course, the president won't be appointing the mayor with the advising consent of the council, or the House of Delegates, excuse me, the governor and the House of Governors. I can get there. And I can't wait to get there. The governor will appoint as opposed to the president of the United States, and the House of Delegates will confirm. We also did add the flexibility, but not a requirement, to add additional courts. So often the courts have stated the need for intermediary appellate court. We're not requiring it, but we've left open the flexibility for the legislature, for the House of Delegates, to make that change. We continued with a Judicial Nominating Commission and Disabilities and Tenure Commission for both the providing appointments or recommendations and for the opportunity to reappoint or remove very much what is in place today. And those were, I think, the biggest pieces.
Okay, any questions?
As I understand it, just to be clear, this Constitution and the language written will provide for absolute continuity of process once
That's
we become
correct.
a state. So if you have a case currently pending in the Superior Court of the District of Columbia, you don't have to dismiss it and reintroduce it in the State Court of New Columbia. That transition will be a smooth one. The current members of our independent judiciary will continue, and new members will be selected in a substantially similar appointment process, except that we no longer will have to wait for the president to pick someone, and we certainly won't have to wait for the Senate to let our nominees sit there without a hearing, as they do now, creating vacancies. And probably nowhere will the administration, will the citizens see a dramatic difference in improvement in services than under a functioning state court system. So.
That's exactly right.
Okay, thank you, Dean Broderick. And so with no further comments, there are no amendments in Article 3. Article 4 is Budget and Financial Management. This article is similar to the provisions that now exist in the Home Rule Act, but has been simplified and updated to eliminate the role of Congress in reviewing the state budget and permit the House to establish the fiscal year it determines appropriate. It is also consistent with our guiding principles. It minimizes unnecessary change to promote stability and ensure responsible governance. This is also expected to encourage stability, market stability during the transfer to statehood, and to strengthen the overall financial health of the new state. And Janet Robbins, who's the Deputy Attorney General in the Office of the Attorney General, is prepared to speak to this or answer any questions. I should have mentioned in the second article, when we were talking about the executive branch, that the role of the chief financial officer remains intact, but for his relationship with the Congress. So the chief financial officer would be appointed by the governor to serve a specified term, and he could only be removed for cause and with the consent of the House of Delegates. So this section in Budget and Financial Management is largely similar to what you are familiar with. Any further comments, questions, amendments, changes? Okay, hearing none, we'll move on to the next article, and Article 4 shall proceed with no amendment. Was that article? What article was that for? Where's Article 5? Which one is 5? I'm missing one. I'm on borrowing. Oh, did we cover those together? I should have said we were doing 4 and 5. So 4 and... Okay, I'm missing my sheet for borrowing. Okay, here we go. So borrowing, Article 5. The article is intended to provide for borrowing by the government in ways that are similar to the provisions for borrowing that are currently in the Home Rule Act. The provisions of this article have been both simplified and updated to accommodate changes for being a state. Most of the comments regarding Article 5 came from the Office of the Chief Financial Officer and the Office of the Attorney General. There were comments from others that are also included in your log. Comments, questions, changes?
Most of the comments, I understand, came from experts in the CFO's office, and I'm going to defer to their wisdom and expertise and accept what they've recommended.
Okay. With no further comments, the Article 5 is unchanged. Article 6, initiative, referendum, and recall. And Betsy Cavendish is available to answer any questions. Betsy, do you want to give a brief summary of what's here?
Good evening. We made a few changes, and we have one further one that's not in the chairman's mark. That one is that it takes 5% of the voters to put a matter, an initiative or referendum on the ballot, and 5% from 5 legislative districts now. And we suggest turning that into 5% of the registered voters in a majority of the legislative districts because, as you just did now, you're increasing the size of the legislature. We also, in pursuant to citizen comments, clarified that we can't have referendums that try to repeal any measures, congressional measures that prohibit discrimination to strengthen our anti-discrimination laws. And we modified it to make sure that public resources aren't spent on recalls of ANC members or State Board of Education members. And some commenters suggested that recall efforts be limited to once per term, but the chairman's mark did not accept that comment on the ground that new facts might arise meriting a second consideration of a recall petition.
Okay. Any questions on initiative, referenda, and recall?
I have a question.
Yes.
Ms. Cavendish, I'm a little confused. You said there's one suggestion that's not in the version before?
It's not in the red line. As we were thinking about the possibility that you might expand the legislature, we thought it made sense to say a majority of the districts, that they get 5% of the voters signing to put a matter on the ballot from a majority of the districts.
So then let me
It
move
used to be 5/8.
Let me move to have that language in
Thank
what
you.
we approve.
Yes.
I have a question as well. I'm a little confused, Betsy. The information that's been provided to me says that the current draft of the Constitution does not provide for amendments through citizens' initiatives. Is that wrong? Do we provide?
No, it doesn't allow for citizen constitutional amendments, but
Okay.
there is an initiative process and a referendum process, but certain topics are limited. There were commenters who suggested that we be allowed to have citizens suggest items that relate to appropriations, citizen initiatives to amend the Constitution.
Yep.
We thought that was a political matter for the commissioners to decide and understand that that's on the agenda for later.
Okay.
And so we didn't make any,
Does
with
this,
regard to these red lines that you see.
does this current language maintain the same protection we have now to make sure that the initiative process respects the principles of the Human Rights Act, and that by majority vote we cannot in any way impede.
Absolutely.
Okay.
Okay, so I have noted one change to the draft, and without objection, we'll include that change to the draft. Hearing no others, we'll move on to Article 7, which is covers a number of things, and Ronald Ross will be prepared to answer any questions about that. So the sections in this article include openness and transparency, the construction of the Constitution, the constitutional amending procedure, and the effective date and other transitional issues. So, Mr. Ross, let me have you speak to this article.
I'll speak to, I think, three principal issues that came in from comments. First, with respect to Section 2, there were a fair number of comments that went to the usage of partisan versus nonpartisan. We have proposed modifications to clarify that the use of the reference to partisan versus nonpartisan will be used only in determining when the name of a political party will appear next to the name of a candidate on a ballot, but will not in any other way limit the authority of the House of Delegates to establish any type of primary or runoff election. With respect to Section 3, the procedure for amending the Constitution, there are two issues that received a large number of comments. The first issue was whether or not the bar had been established too low. That is the percentage of votes required in order to amend the Constitution. And we have suggested raising the required vote of the legislature from a majority to a two-thirds vote. The second issue that received a large number of comments in the public meetings as well as the online comments which were received concern the question of whether or not the initiative process could be used as a means of amending the Constitution itself. And that, as previously referenced, that we deem to be a significant issue for deliberation by the commissioners here. And then finally, with respect to the effect, actually, I'm not even sure that rises to this level. I'm going to stop there.
Okay. So is it clear in this section, Ron, that the Constitution can be amended by the legislature, by a legislative initiative?
Yes. In fact, the question was what kind of a vote from the legislature would be required, and there was significant concern that the threshold that we had set in the initial draft of the Constitution simply wasn't high enough. There should be a higher bar achieved, at least that was the consensus, and that's the recommendation. There should be a higher threshold for purposes of amending a Constitution. And again, that's the legislative process. There's a separate question with respect to whether or not, and if so, how the initiative process could be used to amend the Constitution. And that is an issue that I believe we're going to have some discussion here from the commissioners on.
Let me be clear. The legislative process is only a process for proposing amendments to the Constitution, and even when the legislature acts to amend the Constitution, that still requires under this section a public vote of all voters to ratify it.
That's correct.
Okay.
But it's a simple majority vote at the legislature?
Well, the initial draft went out suggesting that, and we are proposing here, and it should be reflected in your red line, that that is now a two-thirds vote.
Okay. Comments?
I would note that the initial draft reflected the current law. With regard to the Home Rule Act, that the certain provisions of the Home Rule Act can be amended by act of the council ratified by a majority of the voters. And I think that's what was in the initial draft here. So what's before us now is actually a little bit more difficult because it says 2/3 of the voters.
2/3 of the voters or the
2/3 of the
legislature?
2/3 of the, I'm sorry, 2/3 of the legislature, yes.
No, that's correct. It was, in fact, the consensus of the legal group that there should be a higher bar for amending a constitution. We're not talking about changing legislation. We are talking about a document that while it should be available for amendment as the federal and other state constitutions are, it should not be amended as legislation would be. There should be a sense of permanence to a constitution. That is one of the things that distinguishes it from mere legislation, and yet it is not a fixed document. It has to be subject to amendment. So our discussion, and we had a fair amount of it, simply went to how you strike that balance, and that's the proposal you see reflected.
Where are you with the 2/3 versus
I'm fine
simple?
with the 2/3.
Senator?
Yeah. I think it's not quite accurate to say that a simple majority of the legislature proposing an amendment makes amendments to the Constitution like legislation. The big step following that is ratification by a majority of the voters. And one of the comments that I've made to folks who initially were perhaps skeptical of the rapid amount of time that we have to try and draft this and get public comments and go through this was that this was a document that is a starting point, that the voters will have the chance to amend this as they see fit, that the delegates will have a chance to amend this as see fit. And so I don't know that I'm not sure I'm as supportive of raising the bar away from what we have now in the Home Rule Act from a simple majority to a majority of voters to 2/3 of the legislatures. I think that my instinct is to keep it as a majority, knowing that really is just a vehicle for letting voters make the ultimate decision. And I think it's telling that, given our Home Rule Charter, where only a majority of the council had the capacity to amend our charter, it had been used fairly infrequently in our time. So I don't know that I like this version of the draft better, and I'm concerned about going back on statements I've made in public meetings that we hadn't set too high a bar on amending this Constitution. So I'm not sure if there'll be more discussion, but I could certainly see the arguments for both sides.
The 2/3 of the legislature approving?
My instinct, and I'm not saying I can't be persuaded, I see the benefits, and I certainly don't want us to become like some states where literally you're voting on an amendment every year, but that hasn't been the practice here, and I think obviously if we found that the House of Delegates was just going crazy and proposing amendment after amendment, well, then that's easy to amend. But if we found that they were perhaps too stingy, or notwithstanding the collective wisdom of all of us up here, we got something wrong, I'd be concerned about setting that far higher than it needs to be. And it's interesting that we're setting it higher than it is now, and despite the fact that it hasn't been too commonly, we haven't had a lot of charter amendments.
So what I would say to that, and I don't have any issue with the draft that's before us, is that the amendment process should be predictable. That doesn't mean it should be easy. It should be, when we change this document, it should be thoroughly vetted. And so I think having been on the legislature where some of these things go through, I say in hindsight that it should require a supermajority of the members to move it forward, and of course the ratification of the voters. So I'm going to speak in support of the draft as it stands. Are there any motions to change it? Okay, hearing none, this section will be unamended.
Mayor,
yes.
Can I offer one thing?
Of course.
I'm sorry, I don't know that this is the appropriate place to put it, but the 1982 Constitution had under the legislative branch, I don't know why, a code of ethics. And I believe that we should add a code of ethics to the Constitution. It may be redundant because I think that many of the things that the 82 Constitution attempted to address have already been addressed legislatively in the District of Columbia. But I think, given the history of the district, that we should have a simple code of ethics similar to the one that was in the 82 Constitution. And if you'll indulge me, I'll read it quickly. The House of Delegates shall enact conflict of interest legislation which shall apply to all elected and appointed state and local candidates for and the officials in executive, legislative, and judicial branches of government. The conflict of interest legislation shall include, but not be limited to, requirements for mandatory annual disclosure by public officials of economic interests and sources of income, a delegate who has a personal or private interest as defined by law, and any proposed pending bill shall disclose this fact to the presiding officer and shall not be able to vote on that bill. I think it just, I think we ought to put that in. And I'd like to make that as a motion.
Okay, there's a motion on the floor that to add a section for the Code of Ethics.
If I may, to Senator Brown, what does this accomplish, since this is longstanding law in the district?
What it accomplishes in the Constitution, I think, is it codifies a sentiment in the district that we won't tolerate corruption, that we won't tolerate, that we want to make a basic principle of our government that we should have open, transparent government, and that we hold all our elected officials to a high standard.
So, Rhonda, will you want to talk about the openness and transparency section a bit more? Let me pull it up in Article 7. We do outline in that article, Senator, and let me see if I can find the language in Article 7 about openness and transparency. Section 1 reads, the government of the state of New Columbia shall operate on principles of openness, transparency, and democratic participation. Specific obligations regarding participation and transparency may be established by act of the House of Delegates and administrative orders of the governor.
With respect to this question of whether or not we should be embodying an ethics requirement in the Constitution, I guess I would turn to the comments of the chairman here, the co-chairperson. This is really it is embodied in current statutory law. It is these are important provisions, and but they typically are found in statutory law. I must confess, I'm not aware of a single state constitution that incorporates an ethics code, but I can't say I came prepared to speak to that.
But Mr. Senator, let me just jump in, because from what I heard you want to highlight, it was the principles of openness and transparency and democratic participation, which certainly speak to your concerns about elected officials being transparent.
Yes.
Okay.
Yeah, one of the good things about being shadow senator is that it was hard to have a voting record that people can attack you on in this job. And already tonight, I've had to vote against education and a whole bunch of other issues that I support, and now I might have to vote against ethics. So
You're no longer on the BP short list.
But I think what we're really doing here is standing up for a principle that we're forming a new state with the capacity to govern itself and investing in a House of Delegates of public trust to pass laws for our new states, whether it's ethics laws, whether it's laws to engender the policies of education that we want for our children and our community. And I think one of the reasons why we're here is that there were a few things, as much as I credit the aspirations of our delegates and what will really be the founding parents, I guess, of our new state. I think in 82 they got a few things wrong, which is why using the power that the 82 Constitution granted the Council, it had to be amended in 1987. And regrettably, so much time has gone by that even the 87 Constitution no longer meets our current needs. And that's why we're here now. So I'm certainly in favor of strong ethics laws, and I think the district has them. I'm certainly in favor of quality education and all of the other aspirational goals. But I think that if we do our job right tonight, we're going to empower a House of Delegates that's capable of passing proper laws for the people of our new state, ethics laws being among them. And I think there's a difference between the kind of policies that we would want that House of Delegates to pass and the type of tools that we want to put in really the skeleton of our government, which is our Constitution. But I think we're going to empower a legislature to put some muscle behind that, on those skeletal bones, to do the job that they're going to be elected to do.
Senator, I think that's correct. The legislature would clearly be empowered to do so, but I might remind you, under the terms of this document itself, when you have a new state, that new state will start out with the very strong ethics laws that are currently in place. But to your point, that new legislature would have every opportunity to make those even stronger, according to this document.
Okay, and finally, in this section, I think we're still in the same section of the amendment process. Tell me where we are with the citizen initiative to change the Constitution and/or the Constitutional Convention to change the Constitution.
Okay, the recommendation from the group was that the question of the ability of citizens acting through initiatives to amend this Constitution was one that we heard. It was put loudly, and it was put to everyone often. There are fundamental considerations on both sides of this issue. Some who were inclined to promote the most vigorous, direct form of democracy embrace the notion of the citizens being able to assemble, assemble a requisite vote, and to act without going through a council as a filter, but to enact law and, in this case, to fundamentally alter the Constitution. Others, while respectful of that democratic principle and philosophy, had grave concerns about subjecting the Constitution itself to that level of direct participation. There is a concern, perhaps furthered by the current political climate, that you are always subject to a fervor that can produce tremendous momentum that can enact laws without the filter that you do get through the council's participation, through the legislature's participation, I'm sorry. And there's real concern about exposing your Constitution to that influence.
Okay, why don't you say something about the Constitutional Convention?
The question of having a constitutional convention, I guess what I would suggest is this, and it speaks to an earlier point, I believe, I've forgotten whether it was Senator Strauss or Senator Brown, but we have moved forward very, very rapidly to try to put this Constitution before the citizens of the district. This has been a very accelerated process. But I will say we have worked, and by we I mean the committee that has tried to provide legal counsel on this. I also mean the commissioners here, as well as the members of the public who have participated in this process. I believe we've all worked terribly hard. I do not believe it is our view that we have a document that is a flawed document. Right. We feel that we have wrestled with serious issues. We haven't fully resolved them. We're here attempting to resolve additional issues, but the consensus certainly of our group was we do not believe it is necessary to ask the citizens of the district to pass on what we would view as an imperfect document today and hold out the promise that we will very rapidly produce a new constitution. We do believe that we should adopt a constitution that is subject to change. A constitution must be subject to change, but we don't feel that we're basically just offering a marker that should be rewritten in the near or the distant future. And so
okay. That's good. Comments, Phil?
Well, I think we should leave the draft as it is before us. So let me just speak on a couple of proposals. One is that we should allow the Constitution can be amended by citizen initiative. The reality is that we are a small enough jurisdiction geographically that it's not hard to reach the legislators, and if there is a sentiment that there need to be changes to the Constitution, it won't be hard to make that point, to make that case to the legislature. And if it's a overwhelming support, or even, we'll just say a broad support for change to the Constitution, we're just of such a nature, given our size, that, or rather geographically our size, that that case can be easily made to the legislature. So I don't think that there should be the ability to amend through the initiative process. I would also note that the initiative process, and this may just be my own personal opinion, but the initiative process today, in 2016, is not the same as what it was in the late 1970s when it was put into our Home Rule Act. And how it's changed is through case law, I believe it's Supreme Court decisions, folks who are pressing issues on a national level and aren't residents of the district can be not just the financial source, but also the human resource behind getting measures on the ballot for initiatives. And so it wouldn't even necessarily be the voters who are arguing for the change, and we've seen this through a number of initiatives in recent years. So I think that what's proposed before us in the draft is actually a relatively easy process to improve the Constitution in ways that we will see need to be made. With regard to the idea of requiring a convention in, let's say, 5 years, I think that's destabilizing to the document that we have. The document that we have has gone through a lot already, a lot of a lot of analysis by people who really understand this, and then a lot of public discussion. There's the discussion tonight, and then it will be presented to the council where there will be hearings. And there should be some sense of permanence to the Constitution, which is to say that we shouldn't advertise that this is a document that's good for 5 years, and then we will throw it up in the air and see what new we want to come up with. So I don't think that's I don't think that's the best approach. I think that what we have before us is workable, and we should stick with it.
Well, I would just like to say that if we've heard the most comments on anything, it's been this process. I don't think it's about having a perfect or imperfect document, or even a document that needs to be adjusted. I think it's about the process itself. And it doesn't matter if all the lawyers in the Wilson building think this is a great document. It may in fact be. What matters is what the voters think. And the voters have said time and time again they want a constitutional convention. And whether this process is fair or not may be open to debate, but we have to admit that this is an unusual process to have the 5 of us sit up here and decide what's going to be in our Constitution. So I think that the Constitution has to have a provision in it that says within 5 years we have a constitutional convention with elected delegates, and we go through the regular process of looking at this Constitution that we've passed and amending it if necessary.
Thank you. I want to propose another approach. I do feel strongly that I am persuaded by the chairman's comments and what we've heard from our committee that we are going to advance. Believe me, I wouldn't be voting for it if I didn't think it was a structure that would set up our new state. Period. And I also want to leave open the possibility that during our transition into statehood, that there should be a check-in to see if there's some things that we should change, that we should look to change. And so what I want to propose is language, and we'll work out the details of the language if the commissioners support it. And that is, and I think that we could win a unanimity here, which I think is also important, is that the House of Delegates may convene a constitutional convention at the fifth anniversary of statehood. The pressure of that trigger point and date, I think, would have every member of the House of Delegates have the burden of saying why they should not convene that constitutional convention at the 5th anniversary. So I want to put that motion on the table. Is there discussion? Discussion. All those in favor say aye.
Aye.
Any opposed? The ayes have it. Do we have anything else for you, Mr. Ross? Any undecided? Is that it, Laurent? Yep.
One of the concerns, let's say we had an initiative-sponsored amendment process. We talked about the other initiative process in which protections exist to keep a electoral majority from using the initiative process to take away the rights of the minority. If we were to have a citizen-sponsored initiative process, how do we know that that same majority couldn't then use that same process to change the Constitution and take away the protection that we just put in for the rights of a minority? I mean, wouldn't then the same thing that you can't do by initiative now, you could then do by amendment, and then we would lose the protection we put in of what we now call our Human Rights Act, but would presumably be part of a new state protection?
I guess I don't quite understand the question, because we are providing that initiative process, really a referendum.
Right, so the current initiative process, and the one that we're providing in this document, would protect, the example most cited is that when our marriage equality statute was threatened by an initiative sponsored largely by I'm going to use the term out-of-state elements, that wasn't a proper subject because we had laws and a structure in place to do that. If we had a initiative process that could then change the Constitution without intervention by the legislative body, wouldn't that render that protection meaningless? Couldn't that same out-of-state element then sponsor an initiative that may repeal that constitutional protection and then it goes away forever?
Well, the reality is that obviously, not so obviously, by initiative or through the council, there are means of amending this Constitution. And so the constitutional protections that we are trying to embody that would, in this case, prevent an initiative from being a vehicle for repealing anti-discrimination legislation, that protection could itself be overturned by an amendment to the Constitution, in which case you wouldn't have that protection. We're always in that scenario. The question is, will you be able to mount sufficient support for that? And again, if you're not amending, I'd have to see, if you can't amend the Constitution itself through the initiative process, again, this is really one for the commissioners to debate, but to my mind, you stand far less likelihood that you would see that kind of momentum, perhaps funded by out-of-state money, in support of that kind of effort.
Okay, so I think that we have amended to include the section that I read earlier. And let me also be clear that any constitutional convention, I'm assuming that we're saying that any changes that come from that convention should also be ratified by the voters. Is that our intention?
Absolutely.
Okay.
Yes.
So I'll have the staff draft that language and I'll leave them, when we vote on it, the ability to include that language. Okay, so let's move on. Thank you, Mr. Ross, to the transfer of Article 8, the transfer of offices, and Professor Aderson Francois from Georgetown is available to answer any questions. So the commission received about 5 comments related to the transfer of office, 1 comment related to pending actions and procedures, 1 comment related to laws enforced and prior powers, and 1 comment related to voting rights. So let me turn to that section. Professor Francois, is there anything you want to add before we begin? Okay, comments, questions?
At the appropriate time, there was an amendment that
Okay.
We had discussed. I guess now would be the appropriate time then. As I was comparing the 1982 document to the 1987 document, I had noticed that the positions that I and some of my fellow commissioners hold were mentioned and codified in the 1982 Constitution. And I noticed that they were removed from the 1987 version. I am going to presume, not knowing the full legislative history, that one of the reasons why the 87 Council removed the provisions governing our offices from the 82 Constitution that they adopted was because in 1987 they did not technically exist. But we have been debating this document because it is, in essence, the embodiment of what has been known as the Tennessee Plan. And the Tennessee Plan, as we've all heard, and some of us were fans of even before we recommitted ourselves to the process, was states declare themselves to be states. They pass their constitution, they establish their boundaries, and beginning in 1796 and continuing to 1956, when the territory of Alaska, the last territory to use it, you pre-elect your senators and representatives, which is essentially why the voters created the positions that I and my 2 colleagues here are privileged to hold. And so I moved this amendment, 1, at the risk of looking a little self-serving because we're incumbents in this spot, but I guess if we could have the incumbent council talk about the House of Delegates and the incumbent executive talk about the mayor, then somebody ought to speak up for us. It might as well be us. And that is to say that the senators and representatives-elect chosen by the people prior to the State of the Union shall serve in Congress until their successors have assumed office. And in the traditions of Tennessee, Michigan, California, and many other states using this plan, that is exactly what happened. To put this in perspective, the '82 Constitution actually said that our predecessors at the time would serve until the next general election would be held, and then even set a time limit that the next general election wouldn't be held until after the even year election. So it actually gave those incumbents a pretty long term. I don't think we should do that. But I do think that as I reread the Alexander and the Daley case that we had, one of the things that hurt us in our court case at the federal level was that there was a question of standing as we challenged our representation before the Senate. And one of the ways that the Tennessee plan was successfully used by 5 of the 6 states who used it was in the issue of perhaps raising credentials challenges or other jurisdictions. So since we have every other office transitioning, and since the '82 Constitution at least mentioned the offices that we now hold, I would propose that we reinsert just the first paragraph of the '82 language and allow. I also do this knowing full well that anything that's in this document would be superseded by the Enabling Act that would ultimately be passed. So it's not necessarily binding on the Congress, but I would propose that we at least give the option of being ready to be a state and reinsert that section from the '82 Constitution into the present version. So I would move that amendment and see if there are any seconds.
I second.
I agree wholeheartedly. It, among other things, empowers us a little bit, and we sure can use that in this job. So I agree wholeheartedly.
Mr. Chairman?
Well, the difficulty here is that we have a representative, Mr. Garcia, and we also have a Congresswoman, Eleanor Holmes Norton. And so how do we reconcile that unless the maker of the motion is proposing that Mr. Garcia would replace Mrs. Norton? That's one difficulty. You acknowledge that the Enabling Act would be the place that actually deals with this. And so I'm not sure why we would want to get into this, and particularly the complication with the delegate, the Congresswoman, when the Enabling Act is the place for this.
Well, the response would be that I think we want to put it in for the same reason that the Constitutional Convention put it in 1982, which is to establish some credibility and some continuity for these offices that were created by the voters. And I also think we're changing that, and that this would be only for an interim period, so the Enabling Act would be able to set that general election in a near term or whenever. So I don't think we're doing it for a very long time. And so I acknowledge the
So if it's not a very long time, it's okay to depose Mrs. Norton?
Well, actually, by tradition, there's been no instance where the delegate ended up under the Tennessee plan. What happened in Alaska, the delegate ended up taking one of the Senate positions. So I don't think that currently the Enabling Act would allow for the provision of the delegate to automatically. We don't know. We won't be writing the Enabling Act. So what would happen is that until we had permanent elections for 2 senators or representatives, there would be vacancies.
Right.
And this is a provision that recognizes that the people of the District of Columbia, as part of their aspirational goal, had made a provision to fill those vacancies pending a more permanent solution. There's nothing that would say that the delegate would be, I don't think that we could provide for continuity in terms of the U.S. representative for the delegate. We can't do it in this document, but if there is a distinction between a delegate to the House of Representatives and a U.S. representative, is that one is elected with the potential responsibilities to represent a state in the People's House, and the other is to represent a territory as a non-voting member in the current chamber. So nothing would stop the delegate or anybody else for running for the positions that we now hold, but I think the language, I think this language presents a compromise in that we're preserving the intent of the '82 Constitution, which was ratified by the voters, and not making it any more than an opportunity to fill a short-term vacancy, so that everything we've been talking about through this process, becoming a state, being ready on day one as soon as we're acting, we are continuing in that tradition. This is, frankly, one of the ways that voters, prior to this process and prior to voting on this Constitution, has reaffirmed their commitment to statehood is by voting for these senators and representatives elect. And I think that the language of the '82 document, minus the other sections that delay perhaps holding a first election beyond where the Enabling Act would have it, is a good compromise to preserve basically the function that I was elected to hold, and to give this Congress, for whom we will then have to advocate for, the imprimatur of credibility of being an elected representative on behalf of our own constituents.
I'm confused, and I really don't understand what you said in response to the question that I asked. If we were to approve the amendment you're suggesting, what would happen to Congresswoman Norton?
The same thing that would happen to Congresswoman Norton, who currently holds the position right now, in that anybody who holds a position, the non-voting position in Congress, would have to run for one of the new seats.
And in the meantime, who has the seat?
The way the 1982 language reads,
this is too complicated. Would Mr. Garcia take the place of Mr. Norton?
Under this language, if he's the incumbent, yes.
He is the incumbent. We're hoping that Congress will take this up next January.
Right.
Okay, he will be the incumbent next January. The effect of your amendment is that Mrs. Norton would be unseated.
I think the effect
That's a yes or a no.
No, my amendment does not unseat the delegate. The delegate would not be automatically, unless otherwise superseded by the Enabling Act. There's no provision in this document that would in any way provide for continuity of representation of the new state in Congress until the Congress.
But your amendment does provide for continuity, and it says that the three of you at this table would assume the offices of representative and senator.
Well,
correct?
Yes.
Okay, if Mr. Garcia assumes the office of representative, then Mrs. Norton is unseated, correct?
Mrs. Norton is unseated as a matter of course as a non-voting delegate by the admission of the new state.
Right.
But yes. So this is not the 82 language that we're reinstating back does not in any way unseat Delegate Norton. That position is abolished by the admission of the new state.
Absolutely, that's not addressed in the Enabling Act? What happens to the delegate pending the election?
It may or may not be addressed in the Enabling Act.
So you're saying in
we
Alaska
don't know
there was
what
a vacancy?
we won't. Regrettably, there'll be nobody representing the District of Columbia as a voting member who'll be able to vote on the Enabling Act until we're a new state. So we won't be crafting the Enabling Act, and if in fact those who do write the Enabling Act find that a problem, they can correct that. But we have no provision in the interim. We would be a new state, unrepresented, until those elections could be scheduled.
So let me just step back from this, because I think that the senator is right that when we become a state, we no longer have a delegate. And the delegate and whoever would become the representative would have to run. I think what that says is that these seats, nobody has run for the seats that we have in the new state. we don't have a voting House of Representative member, so the delegate, even though how many times she's been elected, would have to run for that position because nobody in the district has ever run for that position. Similarly, and I say this with all due respect, no one has voted for a senator in the District of Columbia. And I would feel very uncomfortable saying to the voters at the same time I'm asking them for statehood, also telling them who their senator is, because nobody has voted for senator. So I know what you're going to say. Nobody has voted for governor either, right? But people have voted for the chief executive of our jurisdiction. People have voted for our legislatures. And the functions of the chief executive, call it mayor or call it governor, are substantially the same. So I would not have the same hesitance, but we don't, these federal positions that we're asking for in a state don't exist presently, and nobody in the district has voted for them before. So what I would ask the delegation, with all due respect, is to put the needs of advancing statehood ahead of this amendment, and with my commitment that we will address it earnestly in our suggestions to as we help craft the admissions legislation.
Madam Chair, if I
Yes.
may. Yeah, and I beg to differ greatly, Madam Chair. I did run for the U.S. Shadow Representative, as it is called, but I do go around the nation preaching that I am the United States Representative for the District of Columbia. So I don't know if you think these are fictitious positions. I hope that that's not the case. I did become the first elected Latino in the city, and I do believe that we should not be putting people spaces to these positions. So as I understood it always, once we become a state, the position of shadow congressperson gets elevated to being the member of the U.S. House of Representatives. That's how I have always understood it. And so, that the delegate gets to rerun, that whatever the case may be, it's a different position altogether. So I would definitely be supporting that amendment.
Well, yeah, and let me add to that. We need to be serious about these positions. If you think that we're unqualified to transcend to the United States Congress, then put up candidates that you think are qualified. It's time for us to decide whether we want to be serious about statehood or not. This is the Tennessee plan. This is the way that it's always happened. For us not to put in this provision would actually be an aberration to what's gone on the 6 times that this plan has been successful. And let's face it, folks, we've been at this for 215 years, and the only thing that has been successful that we can point to is the Tennessee plan. That's worked time and time again. So I think that we need to empower these positions. This is certainly one way to do it. And as Senator Strauss points out, it's a temporary position, and whoever takes those positions will have to run an election.
Let me ask Professor Francois to talk about any legal implications as it relates to the seating of the new senators, as well as how have we dealt with the vacancy in the office of the senator?
Microphone, please.
I think the implications have already been discussed. For all intents and purposes, what happens in these offices will be a function of what Congress decides. So it's all a matter of what the Enabling Act or the Admissions Act would provide.
Has the Congress, in the cases that you reference, seated the senators?
Yes.
Have they refused to seat the senators?
No. Initially, they have, and then ultimately, in the case of the prior examples, in Tennessee specifically, in Michigan, in Oregon, and in California, the Senate went on to eventually accept and seat those senators.
What does eventually mean?
Huh?
What does eventually mean?
When they were
If they-
admitted as states, upon
When it
statehood.
became a state.
Upon statehood, they were admitted and sworn as senators without having to run again. In the question of Alaska, they called for a new election and did not seat the Alaska delegation in advance. So in 5 out of the 6 cases, they did. This language does not bind Congress. Obviously, we can't. So they would have the discretion under the Enabling Act to do so. But in the absence of this language, here's what Congress is not empowered to do. We would be a state for however long a period of time until those new elections could be held that would in fact be unrepresented in that body. There would be nobody there, whether it's 30 days, 60 days, 90 days. Legislation would be ongoing, and the District of Columbia, that has been without a vote in Congress for over 200 years, would have to go without voting representation in Congress for however many additional days until new elections could be held. And so this act would allow, this language would at least permissively give Congress the authority to enable, to seat people who have been elected, I respectfully disagree, to the offices of senator and representative. Now, if Congress refused to do that, our Constitution here does not supersede the legal power of the Enabling Act, but it is a central policy statement that would then go to the voters. And frankly, it was that initial policy statement that created these offices. These offices were created by the Statehood Initiative when we first enacted the Tennessee Plan. And so I would simply not, and while it looks self-serving, the reality is I would not be faithful to the office that I hold or to the voters that elected me if I did not at least reinsert this original language in there so that we would shorten the time in which the district would be unrepresented.
Okay, Phil?
Yeah, so I have several questions for the professor, if I may. First of all, is it correct that the Enabling Act will determine this issue?
Yes. In other words, this is not really a constitutional question, but rather a policy question. The fact of the matter is, regardless of what language we adopt here, the Enabling Act itself will determine the issue. Congress can accept it or not.
And the Enabling Act could specify that the 3 elected representatives who are here at this table, the representative and the 2 senators, the Enabling Act could specify that they will have the seats pending an election. Is that correct?
Are you asking me whether or not, in the absence of the amendment, Congress itself on its own could insert language into the Enabling Act saying that the current members should serve until an election?
Yes.
I'm not sure.
You're not sure?
I'm sure. What I am sure about is that if the language is inserted, Congress has the option to accept it or reject it. If the question is, supposing the language is not accepted, that the draft remains as it is, can Congress sua sponte insert its own language in the Enabling Act to say that the current members would serve until the election? That I'm not sure about.
Now, with regard to Tennessee, they had so-called shadow representative.
Yeah.
And then Tennessee was admitted. Were the shadows seated?
I think at some point, yes.
No, not at some point. Were they seated on an admission?
Yes, Mr.
Absolutely.
Mr. Mendelson, they were. Senator Blount?
Well, several people have said no to me, so that's why I'm asking the question. Are there others in the audience who know and disagree?
Read the encyclopedia. It's right. Jesus.
They were seated.
May I just ask everybody? I know
Provide
that
their names for it if you'd like.
order, please. May I just ask everybody? I will be happy to call on any members of the commission or any members of the legal advisory committee that can advise the commission. And I recognize that it's an awkward discussion, but please remember decorum.
What about the other states? Did Congress seat each of those shadows?
Yes, I mean, what the senator has discussed is accurate. Some of them were seated. The vast majority of them were seated eventually.
What does eventually mean?
Meaning some of them were not automatic. There was a period of time
As in
following
an
admission.
election?
I'm sorry?
As in an election?
I believe some of them were seated prior to an election.
And some, but not all.
Not all.
Okay,
Not
so the
as far as I
Tennessee
know.
plan doesn't call for this amendment specifically.
The Tennessee plan doesn't call for the amendment. This is really, if I may put it this way, a political decision as to whether or not the commission decides to do this. But there is nothing about the Tennessee plan that demands that it must be done.
Mr. Chairman, if you're going to be guided by historical precedent, the Tennessee plan called for it and was followed, and those senators were seated.
Yeah.
The California plan, the Michigan plan, the Oregon plan all followed the same thing. The sole exception of the states that used this successfully was Alaska, where the Enabling Act made separate provisions, and for a while the territory of Alaska was a state that was unrepresented in Congress. So in 5 out of the 6 states that have successfully gained admission to the Tennessee plan, actually those members were seated permanently as members. I'm not proposing that. I'm proposing that in the interim, until such time as new elections are called, that those seats not remain vacant, and that the senators and representatives-elect be authorized by the people of D.C. to be seated, which can only be done with the consent of the Congress.
And is it clear, Professor, that with the Admission Act that Congresswoman Norton would be unseated?
Yes, because automatically her office would no longer exist. She's a delegate now. And this, if DC is admitted as a state, then automatically her office is abolished.
And that couldn't be addressed in the Enabling Act, as in she continues to represent the district until there's an election?
It goes back to the earlier answer. Yes, Congress has it within its authority to make such provisions.
Does have the authority to make
Yes.
that provision.
Exactly.
So it doesn't follow that she automatically would be unseated.
What I meant to say is that if Congress doesn't make that provision, then the fact that D.C. is admitted as a state and she's a delegate means that her office no longer exists.
Sure.
If what you're asking me is whether or not Congress could, in the act, elevate her to a new position as representative of the state, arguably yes.
It's clear that the Enabling Act is going to answer the question,
Yes.
not what we write here on this matter. It's the Enabling Act that will answer the question.
That's correct. I think the only question is whether or not, as a policy decision, as a political decision, the Commission believes it is wise or not to insert the language now into the Constitution.
One other question. Each of the 6 states, I believe there's 6 states that have followed the Tennessee plan. That's what I've heard here tonight. How many of them had congressional delegates such as Congresswoman Norton? Do you know?
No, not off the top of my head, no. I don't know the answer to that.
All of the territories had non-voting delegates so that included Tennessee and the 5 other states.
Had non-voting,
Had
not
non-voting
shadow,
delegates.
but non-voting
Had
delegates.
non-voting delegates.
Thank you.
Madam Chair, if I may,
Yes.
I think that part of the challenge here is that, we're trying to accommodate and look at individuals more than anything else. And let me just say that when I read the Tennessee plan, if we have been doing it as we should have, which is funding the delegation, you probably would have had very prominent congressional, shadow congressional delegation, and we probably wouldn't be where we are today in trying to say that, we don't have senators and that we don't have these positions, because we would have our shadow delegation being very visible and being known everywhere. And I think what we're trying to do here is very clear that the Tennessee plan called for the people who would be burdened mainly to get statehood, which would be your shadow delegation, would ultimately reap the benefit of all the work that they would be doing, which is get statehood. Here we're having a challenge because we haven't funded our delegation, so we don't know that, the delegation is really doing the burden of this work.
Respectfully, Congressman, and I have great respect for you and what you do and how you have advocated for statehood. But if anybody is here to talk about reaping the benefits for themselves, that is the wrong conversation. And frankly, I'm offended by it. I'm offended by it.
What?
So I have the floor, sir. I have the floor.
Okay.
Remember your decorum, sir. I'm only responding to what I just heard, that the shadow delegation should reap the benefits of their hard work. The shadow delegation should do what it was elected to do, and the benefit is that you did a good job. That's the benefit. That's what we get elected for. And so if you're doing it for any other reason, that's problematic.
Madam Chair.
And more than that, I would ask everybody to think sincerely about what you might do to our efforts moving forward by talking about your personal gain. So let me just say that. And
May I
would
rebuttal,
you
Madam
like to
Chair?
correct what you said?
Yes. Well, I think you misunderstood what I said.
No, I heard you clearly.
Well, what I meant to say then, let me then say what I meant to say is
Okay.
that I think what I'm trying to say is let's get a clear picture of who ends up being the city members of Congress once the Tennessee plans is put in place. And what I was saying is that a way to see it is that a lot of the people in the past who worked for Statehood were the people who had those positions, the shadow members of Congress. And I am not saying that I want to reap the benefit. What I'm saying is that, in fact, I don't really mind. For all I care, I'd be more than happy to seat to our delegate who's done an incredible job. But what I was trying to clarify is that I think it would be more clear for all of us if we had a funded delegation like they did back in the past who did all this work, and we wouldn't be saying, are you real? Do you really have that position? That's what I was trying to say.
No, and Congressman, I don't mean to suggest that you're not real. Obviously, I voted for you, so I know you're real, and I appreciate the work that you're doing. But you do not serve in the Congress because we are not a state and we do not have a congressperson. We have a delegate. That's a question we can certainly put to the people if they see a difference, but I think they do. But that's another point. I think that we've heard that it's really not the Constitution that will decide this question anyway. I recognize that you want to push it here, but this will not be the document that leads to a senator or a congressman being seated in the new state. So I question whether it's appropriate at all to have this amendment.
If I could speak to that, the reason I've
And I'm gonna request some parliamentary assistance. Who is going to be our parliament? Who's serving as our parliamentarian? Mr. Cook. Mr. Cook. Thank you.
well,
The question is going to be: is this an amendment in order?
Is the question in order?
It's a question in order. Please take the podium.
I'm down for that.
So we're considering an amendment that would it's kind of aspirational, really. It's trying to get a sense of the body as to whether we think that this is a political question that we should answer here. The question is, if we know that it will also have to be added in the Admissions Act. In the Admissions Act, that's the only thing that can affect it.
Okay, there's sort of two things. I think the problem is I don't agree with the premise. That is to say, it's not the Admissions Act is not the only thing that can affect it. The U.S. Constitution actually controls it. So the Admissions Act is an act of Congress. The Constitution is the foundational document. The Constitution defines who can be a state. And it defines who represents the states in the Congress of the United States. So the Admissions Act can't trump that. So contrary to some of the discussion that was heard here, I think the fact of the matter is that when Tennessee elected representatives and senators and sent them to the Congress said, go away, because until you are a state, you cannot represent someone to be a member of the Congress. So I think, is it in order? the body can do whatever it wants. So it's in order in that sense, but is it going to accomplish the objective that I think the sentiment is intended to express? The answer is probably no.
Okay. All right, so there's a motion.
Madam Chairman,
Yes.
can I just say, look, the Tennessee plan is aspirational. The entire Tennessee plan is aspirational. That's what it is. You can't walk up to Congress and say, we want to be a state, and have them say, oh, you know, we didn't know that, so that'll happen. Only Congress can make us a state. And I don't see how we can sit here and say that every member of the D.C. Council becomes a delegate and the mayor becomes the governor, but the other elected officials that have been duly elected by the people of the District of Columbia don't count.
Well, the only thing I would say, sir, in response is that the U.S. Constitution says who can be a member of the national legislature. As far as the state legislature is concerned, the people of Kansas, the people of Arizona, the people of Iowa decide who is in their state legislature, not the U.S. Constitution. So it is possible. Now, I'm not talking about what has to happen. I'm just saying it is possible for the citizens of the District of Columbia, through their Constitution, through their acts of a plebiscite, to decide whoever they want to be their local legislators. But the people of the District of Columbia don't have the power to decide who is their representative in the Congress, because the Congress says first you got to be a state, and then there's some other qualifications that the Constitution imposes.
Let me just.
Well,
as the maker of the
5 other states did it.
Mr. Cook,
5 other territories did it.
first of all, I know you're not suggesting that it's out of order for the commission to take language word for word from the 82 Constitution and put it back in this Constitution.
He didn't say that.
I specifically rejected that position. The body can do that if it chooses.
Let me be clear. This is not an attempt by us to gain benefits for us or to do that or to empower us. This is a question of whether or not we will empower the Congress to allow interim representation in the national legislature if they choose. And who in, so I think that was the intent of the 82 Constitution. That was the intent of the Statehood Initiative when these positions were created. And as we went forward with these discussions of the Tennessee plan, as we're going forward and redoing the Constitution, we're not re-electing a shadow congressional delegation because that was done in place. But if we hadn't already been serving in place, if we were following the Tennessee plan, that's exactly what we would be doing. So really, if we don't put this language in, all we're saying is that there'll be no mechanism for interim representation in the national legislature pending the first election of congressional representatives. We will lose the delegate spot because that position no longer exists, and there will be weeks, months, days in which the District of Columbia is the 51st state, having been admitted, would be unrepresented, and this provides the Enabling Act with a vehicle, should they choose to. I'm fully aware that we can't control that, to, in the interim, allow for continuity of some kind or some kind of interim representation. I suppose we could enact, we could say that the delegate, the mayor, the chairman would take the seats, but that's not what the 82 Constitution said. That wasn't the language, so that was
My point is not that this body or the citizens can't do exactly what you've said. My point is that I don't think that has any legal effect on the Congress of the United States because of what the U.S. Constitution says. The Admissions Act is not likely to sneak up on us. When Congress chooses or agrees to admit the District of Columbia or New Columbia to the Union, there will be an Admissions Act. There will be a way to time it. There can be elections so that there will not be a gap or not a gap of any significant consequence. It happens from time to time that members, that states, citizens of states, have no representative in Congress for a period, and they have to have a special election. It happens.
It's not, to my colleagues on the commission, it's not my intent to do anything except restore the original intent of the 82 language in this. It follows precedent. It follows the Tennessee plan. This is not an attempt by us to take any offices that we weren't elected to. This is an attempt to this is an attempt to restore the original statehood language so that if there is if the Enabling Act would provide for a gap in representation, it would allow for a mechanism for interim representation only until the elections were held. In fact, I'm certainly not moving the other amendments of the Act that would expand the terms of those interim offices. They would exist only to avoid a gap in representation. We've been voteless for 200 years. It would be a pity if the people of the District of Columbia remained unrepresented in Congress for a day longer than they had to be, especially when, since 1990, citizens had been electing people to these positions as a testament to their commitment towards achieving statehood. So, I
can't speak. I'm not attempting to accuse anybody of any sort of motive. I was asked a question about process, whether it was in order. I believe it is in order. My only cautionary was that I don't think it's going to actually accomplish the intent that the action is proposed, but it certainly is in order to do.
Okay, thank you. Who can speak to vacancies in the federal offices? Filling vacancies.
So if the question is, when we become a state, is there a vacancy? And for that, we look to the U.S. Constitution, and it has specific provisions both in Article 1 with respect to the House of Representatives and in the 17th Amendment with respect to the senators. Remember, the senators were originally chosen by the legislature, and now they're popularly elected. So let me read you from the senators first. When vacancies shall happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided, however, that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election the legislature may direct. Translated, we've got to have an election for senators unless the state legislature empowers the governor, in our case, to appoint someone in the interim, and then you have an election at the next regular scheduled election. All right. The House of Representatives provision is less capacious regarding appointments, and it's in Article 1, Section, Section 2, the next to last clause. When vacancies happen in the representation from any state, the executive authority, governor, thereof shall issue writs of election to fill such vacancies. So no provision for any kind of appointment. And so if, in fact, what happens is on day one we become a state, there presumably is a vacancy, and I think that the Congress would follow what the Constitution says about filling vacancies, and we would have to have an election. That's my interpretation. Now, I don't know whether these issues were raised when the other states came in and whether anybody objected or not. And, of course, the Constitution also provides that each house shall be a judge of the elections of its members, so that they could, if it weren't raised, would have the ability to pass on that. But I would think that if these are in fact vacancies, which I think they are, they would be filled this way. Now, there's an argument could be made that these aren't vacancies because there was no one in there to begin with. I think the better argument is they are vacancies and should be treated as such, and I think that the Congress would do with it. At the very least, we should put in there, subject to the Admissions Act, as part of it. If the senator's amendment were to pass, we ought to say, subject to the Admissions Act, to make it clear that we don't think we have the authority to override what the Admissions Act says.
Mm-hmm. I'm clear that we don't have the authority to override what the Admissions Act says. It's only an opportunity to enable the Admissions Act to provide for interim representation. So I would accept your language as a friendly amendment. But I would, while the co-chairs are deliberating, the shadow senators of Tennessee, William Blount and William Koch, were seated in 1796. In Michigan, Senator John Norville and Lucius Lyon were seated by the Senate without a subsequent election in the state of Michigan. In California, Senators-elect William Gwynn and John Fremont were seated by the Senate without a subsequent elected. In Minnesota, Senator James Shields and Albert was among the senators seated. Oregon legislature elected Joseph Lane and DeLazon Smith to the Senate. They were seated without a subsequent election. So the Tennessee plan is literally, there has been no, beginning with Tennessee, there has been no Tennessee plan without the election of shadow senators as part of it. And I have been privileged to participate in this process as part of the Tennessee plan. But I think if we're going to be true to the Tennessee plan and true to the strategy, we should embrace all aspects of it. If in fact there has been no purpose in holding these offices, then why are we? Why did the voters create them? And what are we here for? So, and again, the ultimate decision is made in the Enabling Act, but it would be a pity if we didn't at least provide the opportunity for the filling of those vacancies. As for whether we meet the federal qualifications, the act that created our offices mandate that anybody holding these offices meet the federal constitutional requirements.
Okay.
I had to be 30 years of age and meet, and if there's a vacancy in my office, the procedure for filling that vacancy is by executive appointment. If there's a vacancy in the rep, it's by a writ of election. So these offices were created to deliberately meet all the federal requirements and to serve no other purpose except to advocate for statehood on the way towards complying with the language of Section 6A of the 82 Convention.
Okay. No further discussion. I'll call for a vote on Senator Strauss's amendment. All those in favor say aye. Aye.
Aye.
And nay? Nay. So the votes are 3-2. The ayes have it, and the amendment passes. And we are there other topics that we have not discussed?
We haven't discussed, Madam Chairman, we haven't discussed the name.
Oh, I'm sorry.
That was,
You're quite right.
That was something
Which
that
is
was brought
A,
up
under
time
3A.
time again.
So we haven't actually gone to the general comments, and I think Beverly Perry is going to speak to the general comments log. Which include the state name.
Good evening.
Good evening.
Madam Chair, we received 150 general comments, and they were all over the place. Many of them were congratulatory and complimentary, but the one that we received the most was about the name. And the the general comment about the names was, or the comments were, that there were several names. Some suggested that we name it after a river, Anacostia or Potomac. There was one that said that we should name our state after a historic figure. It should be Douglas Commonwealth. And then we also had a recent suggestion that we should name our state New Washington, D.C., to indicate the vibrancy of being new and taking on a new attitude, New Washington, D.C. And what would be good about that, it would be, we have several businesses in town. We have many, we have the government here, and we thought that the federal center could be Federal Washington, D.C., was a suggestion for the federal center. And you see the map just at lime green area would be federal Washington, D.C., and all of the gray would be new Washington, D.C. So those were the suggestions of the name. And as I said, of those 150 comments, more of them related to the name than any other thing.
Thank you. Comments, questions?
I'd like to say, Madam Chair, that I think we should keep the name New Columbia, and I'll tell you why. I know there have been objections to the fact that this may somehow honor Christopher Columbus, who was not a very nice guy. But actually, the city was named after the goddess Columbia. Columbia was a collective name used to describe the 13 colonies, and when Washington appointed surveyors to come to the district or to survey the district, they did so, and they named the territory Columbia because they thought it represented all 13 colonies. In addition to that, I would add that it's the only name that's ever been voted on by the people of the District of Columbia. Through a constitutional convention, they chose this name, and this name was ratified. And really most important for me is that for 34 years, people have used this name to push this movement forward. And as we speak today, there's legislation in both houses of Congress called the New Columbia Admission Act, which will be active if this resolution, if this referendum passes in November. That legislation, which now has 133 members in the House and 19 in the Senate, will be active legislation. So I think it's confusing to change the name at all.
Senator, the legislation would have to be reintroduced, so we could easily...
Not in November.
Oh.
In January. It would have to be reintroduced. But for the last few months of the year, it would still be the New Columbia Admission Act, and we can always vote on a new name. We voted on this name. So for those reasons, I would like to keep New Columbia.
Okay, I'm going to put a motion on the table to maintain the name New Columbia. All those in favor say aye. Aye. Any opposed? New Columbia it is. All right. Do we have anything else on the boundaries? The boundaries have been discussed and are a part of the commission packet. Anything else? Okay, the OP Director, Eric Shaw, is here if there are any questions on the boundary. Hearing none, we will, as part of, well, actually, let me just move on to item 4. The vote on the following. The commission report that's in front of you. We will leave staff the ability to add a section about the discussion at this meeting. You also have the draft constitution as amended. You have the map.
Move adoption of the map.
Can we move all three in block?
So moved.
Okay, so you have on the table the commission report, the draft constitution as amended, and the boundary for federal Washington and for the state of New Columbia. Any further discussion? All those in favor say aye. Aye. Any opposed? The ayes have it. Let the record show that there has been a unanimous vote of the commission to forward to the Council of the District of Columbia the Commission's report, the draft constitution, and the map. Let me turn to any other business before the Commission, Mr. Chairman.
I would just like to note, many folks may already know this, a resolution was introduced in the Council today by all members of the Council to approve the submission of a proposed advisory referendum to the Board of Elections for inclusion on the ballot November 8th. And this measure was retained, which means it will be taken up by the council for a vote on July 12th. And then separately, based on the last vote, the council's prepared to receive the Constitution, the report, and the map.
All right.
All right.
All right, congratulations, everybody. So with that, there's no further business before the commission. We're adjourned.
All right.
Thank you, gentlemen.
Okay, here.